All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So, Phil, we kind of chatted about it a minute ago, but I have to dig into it a little bit because, the way the polls were shaping up prior to Biden dropping out of the presidential race is it did look like Trump had a substantial lead in almost every poll, not every poll, but almost every poll, and also in the swing states. He was leading by substantial numbers in many of the swing states. And, we know what a Trump administration looked like for the labor and employment agenda because he was president from 16 to 20. And it was definitely more pro-employer than this current administration, which is decidedly, in my opinion, anti-employer. So we sort
Hold
of
back,
look.
Burt. Just
Yeah,
you got to soften that edge a little bit. Soften that edge a little bit.
We look back to the Trump administration, and that's where things seemed like they were heading. And now, of course, with Biden dropping out, that means that the match, his depending on the poll you're looking at, has at least narrowed somewhat, and she appears to be a much more viable candidate than did Joe Biden. And so one of the things that we've seen just in the last day or so is that there's a wave of organized labor that has already come out to back Vice President Harris in her presidential run. She's obviously second in command. Well, that's debatable, but she's currently second in command to a president who has claimed to be the most pro-union president in the history of the United States. And so several major unions, including the Service Employees International Union, the Communication Workers of America, and the United Farm Workers rushed yesterday to endorse her. And they had not all yet endorsed Biden, but they have very quickly endorsed Vice President Harris. And, it's very important that with these unions because they may be seen as a way for her to win over workers in battleground states who are really disenchanted with the Democrats after foreign trade agreements really took quite a bite out of their lives. And that's coming from that's a quote actually coming from a former chairman of the NLRB who teaches labor and employment law at Stanford University. That's not just my opinion. That came from a former NLRB chair. And so it is interesting that how this could shake up the race. Of course, we know, and we'll talk about this in a second too. We've talked so much on the show about Chevron deference, reining in the administrative agencies. If Harris wins, I wouldn't expect much of a change at any of the administrative agencies from a policy standpoint, but those administrative agencies will still be held to the standard that the Supreme Court overturned. They'll have to adhere to the new standard when the Supreme Court overturned Chevron deference. And I think the legislature is going to have to play a much more active role. The legislatures become more important than the administrative agencies. So we will have to keep our eye on this to see what shapes up during the campaign and how they portend themselves. Don't forget, President Trump had the president of the Teamsters Union. He invited him, and the president of the Teamsters Union accepted and spoke at the Republican National Convention, which again showed that maybe the union itself isn't going to endorse President Trump, but a lot of the members of those unions do support the president. I think that, or President Trump, and I think that was a recognition of the support that the union members themselves have for President Trump. So really going to be interesting, not only just to see how it shakes up the election, but of course, as a labor and employment attorney, I like to look and see what impact it might have for all of our listeners and for our clients and members.
Absolutely. No, it's going to be a very interesting time. Okay, Burt, what else do we have?
All right. So how many times, Phil, in the last probably 6 months have I mentioned the phrase Chevron deference?
He does this kind of thing. Like, I'm going to 4 times. I don't know.
Four
Come on.
times. Well, I don't have an exact count either, Phil. So there's no wrong answer. I
But
tried
you
to.
have mentioned it many times.
Yes, I
Yes.
tried to serve you up a softball, and now you're making fun of me. I mean, geez. So, all right. Again, talking about Chevron deference, there's a very significant development that occurred last Friday after our show, and the National Labor Relations Board last week decided to drop its appeal of a Texas federal judge's decision
Mhm.
that struck down the NLRB's joint employer regulation. So in a motion filed with the Fifth Circuit last Friday, the NLRB dropped its appeal, and it was of a decision in March that this judge had sided with a coalition of business groups that challenged the agency's 2023 rule detailing the standard for whether 2 linked entities jointly employ the same workers. So while the board in its motion said it stood by the validity of the rule, it wanted the chance, quote, to further consider the issues identified in the district court's opinion in the first instance, end quote. I think we can all read between the lines there that it dropped its appeal because of the Supreme Court's decision in Looper Bright. And so what this really means, though, Phil, is that dropping the appeal means that the Trump era standard that the board had sought to replace with its 2023 rule remains in place for now. So we're not sure what the board's next step will be. So the NLRB's methodology for determining whether 2 entities are joint employers is a standard that's flipped back and forth multiple times since the Obama administration, and that's what we talk about when we talk about Chevron deference. And the significance of the Supreme Court's decision is that every 4 to 8 years, the administrative agencies in this country change the rules on the employers, and it's difficult for employers to comply. And so the scope of this standard is really significant because it determines whether workers can force entities like franchisors or the users of staffing firms to the bargaining table or hold them liable for labor law violations.
So this is, I mean, this is the upside to that decision is going to be consistency for people like Nicole and every other organization who's just really trying to say, tell me what it is and I'll work on getting it right, but quit changing it. Let's quit moving. We're moving the target too much.
Exactly.
And I think the NLRB in this case has said, okay, we get it. And they backed away. Maybe wouldn't have done that in a different time before Chevron.
Before Looper Bright, I agree. So and just so everybody's up to speed, we've talked about it numerous times on the program, but under this NLRB 2023 rule, an entity would be considered a joint employer if it controlled at least one of seven working conditions, such as pay, health, safety, and hours. And the rule held that the entity could be a joint employer even if it only had indirect control over one working condition, even if it had never exercised the control. Even if it had indirect control but never exercised it, it could be deemed a joint employer. That 2023 rule had much more expansive reach than the regulation the agency issued in 2020, which required an entity to have direct and immediate control over workers in order to qualify as a joint employer. So, so the Trump.
I'm sorry. That's why we have Burt Garland on the program. He's got the information. He's giving you insight. Okay, Burt, we got to keep going. What else?
All right. On the lighter side, Phil, not lighter for the people involved, but maybe for our audience here. PepsiCo and Frito-Lay have been sued over Flamin Hot Cheetos origin story. So a retired Frito-Lay executive previously touted as the inventor of Flamin Hot Cheetos sued both entities in California state court for defamation and racial discrimination, claiming there's a smear campaign to discredit him that has derailed his motivational speaker career and a planned documentary. The plaintiff in that case, Richard Montañez, he's the son of a Mexican immigrant who got his start at Frito-Lay as a janitor. And he says in his lawsuit that he was the inventor of Flamin' Hot Cheetos, and The companies had been more than happy to leverage his rags to riches story to drive the product sales and popularity. But then about 7 years ago, executives turned on him and began a campaign to deny his role in the snack foods invention. So he's suing them for defamation, fraud, misrepresentation, and false promise, intentional interference with prospective economic advantage, unjust enrichment, and a violation of California's unfair competition law and the state's Fair Employment and Housing Act. Basically that when a Los Angeles Times reporter was preparing a story about the origin of Flamin Hot Cheetos in 2021, Frito-Lay allegedly or did issue a statement to the reporter saying that, quote, none of our records show that Richard was involved in any capacity in the Flaming Hot test market, end quote. And after he reached out and contacted the company, the company also said that doesn't mean we don't celebrate Richard, but the facts do not support the urban legend. And so days after the article was published, Frito-Lay issued a statement saying that its earlier statements had been misconstrued and attributed the launch of Flamin' Hot Cheetos to several people, including Montañez. But the lawsuit says this half-hearted clarification was simply too little too late. And this is the makeup of a finger-licking good story pending out in California. And I'll, of course, keep track of this one, Phil.
Questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.